Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been significant discussion in the community regarding what if. What if Brian C. Kohberger decides to appeal his sentences? Now, there's no indication that he is going to appeal, but in terms of having a discussion, what would he need to prove? Because recall, he pled guilty. He signed a plea agreement that included a waiver of any appellate rights to potentially appeal his convictions to a higher court. But there has been a landmark decision in the United States Supreme Court just this past week on June 18th. 2026 in the case of Hunter versus United States. In this 8-1 decision, the United States Supreme Court found that the miscarriage of justice standard exists uniformly coast to coast in the United States that would invalidate what would otherwise be a legal appeal waiver in plea agreements. In such situations, SCOTUS has found that an appellate waiver is unenforceable if enforcing it, allowing it to stand, would result in a miscarriage of justice to the point that it would give rise to an egregious error that would seriously call into question, discredit the entire judicial system itself and fundamentally undermine the fairness of the proceedings. And fairness of proceedings is a hallmark of due process. That's a constitutional guarantee. Hunter addresses appellate waivers, and because he's in Idaho, the Uniform Post-Conviction Procedure Act, Idaho Code Section 19-4908. This is a remedy that's available to people who wish to appeal their convictions. The burden is on the party who is looking to appeal a prior conviction. And remember, you're dealing with a situation here with Mr. Kohberger where he gave up his appellate rights. So the Hunter standard has to be shown as well. But under the Idaho law, it reads, remedy to whom available. Conditions: A, any person who has been convicted or sentenced for a crime and who claims, 1, that the conviction or the sentence was in violation of the Constitution of the United States or the Constitution or laws of this state. 2, that the court was without jurisdiction to impose sentence. 3, that the sentence exceeds the maximum authorized by law. 4, that there exists evidence of material facts not previously presented and heard that requires vacating of the conviction or sentence in the interests of justice. 5, that the sentence has expired, probation or conditional release was unlawfully revoked by the court in which was convicted, or that he is otherwise unlawfully held in custody or other restraint. 6, that the petitioner is innocent of the offense, or 7, that the conviction or sentence is otherwise subject to collateral attack upon any ground of alleged error. So these are the grounds. There are some here that don't seem to apply in Mr. Kohberger's case. We're going to start out in the next episode by looking at 1, that the conviction or the sentence was in violation of the Constitution of the United States. So please join us next time when we start going through these grounds that Mr. Kohberger or any defendant would need to show in order to appeal their conviction or sentence in Idaho under Idaho Code Section 19-4901. Thank you for joining us here today.